Welcome to the SOS Gray Rhinos International Space Law elective. I'm very pleased to be able to deliver this information to you as you're going through your education process for the Space Force. So my discussion for today is going to be divided into two separate PowerPoint presentations. So there will be two files for you to view for the purposes of this elective. So this presentation is the first one covering important international law principles. So the reason that I go into international law principles first is that international space law is a subset of international law in general. So in order to be able to understand how to apply and how to interpret international space law, you have to have the basic tools for international law to start with. So the lesson objectives today for both lessons, it's the same three objectives. The first objective is going to be covered in this first PowerPoint, which is to describe how laws and norms affecting space operations are established, because those are international laws and norms. So the overview of this PowerPoint is we're going to talk a little bit about sovereignty. We're going to talk through the sources of international law as articulated in the Statute of the International Court of Justice. We're going to talk about how to interpret treaties in accordance with the Vienna Convention on the Law of Treaties. So we'll use those treaty interpretation rules when we're talking about the Outer Space Treaty and the other space-related treaties that the U.S. is party to. We'll talk a little bit about the law of state responsibility, and we'll talk a little bit about law of war, because international law as far as military conflict goes, LOAC, is going to be applicable for space as well. So the Treaty of Westphalia in 1648 is what we think of as the origin of the modern concept of sovereignty. And so since the Treaty of Westphalia in 1648, we have had this concept of what a state is and how a state operates as a member of the international community. So there is equality among states, and what that means is certainly not that states have equal power, but that states have equal rights. So states have jurisdiction, and they have a government. And that jurisdiction extends to the population and the territory of that state, both the population and the territory individually. So in order to be a state, it has to have a territory, it has to have a population, it has to have a government that can make laws in order to enact and enforce that jurisdiction that a state has over its territory and its people. So within jurisdiction, you have two different components. You have what's called jurisfaction, which is the part of jurisdiction used to make laws that will apply to that population and or territory. And you have jurisaction, which is the enforcement of laws for that population and or territory. And so those two components are what make up that jurisdiction overall that a state will have over its people and over its territory. There's also jurisdiction that states have over their vessels, whether we're talking about a ship on the high seas, whether we're talking about an aircraft in flight beyond the airspace of the state, or whether we're talking about a space object in space. So when we're talking about those kinds of objects or vessels, we're talking about quasi-territorial jurisdiction. It's not territory, it's not the territory of the state, but it's a stronger form of jurisdiction than the jurisdiction over just an individual who is found outside of the territory of the state. So there is personal jurisdiction as well over individuals. So if individuals are on the high seas or in the air beyond the limits of airspace, or if they're in space, then the state still has jurisdiction over that person. But the strongest form of jurisdiction is territorial jurisdiction. The second strongest form is quasi-territorial jurisdiction over those ships or aircraft or space objects. And then the third strongest form is the jurisdiction over the person. So the state of registry for the ship or the aircraft or the space object will be the state that has jurisdiction in a non-territorial area in order to deal with any issues that may arise on that vessel. So as I mentioned, states have sovereign equality. That is codified within the Charter of the United Nations in Article 2, that the UN is based on the principle that all states are equal members. Again, not that they have equal power, but that they have equal rights to govern their own population and their own territory, to be free from the interference of other states in that governance. So Article 2, Paragraph 4 of the UN Charter tells us that there is a prohibition on the use of force or the threat of use of force on a state's territory or their political independence. So the Lotus Principle is an important principle in international law, and it comes from a case from the predecessor court of the ICJ in 1927. The picture that you see on the slide is the ship called the Lotus, and so the case is referred to as the Lotus case. And the principle that came out of that case that's relevant for our purposes here today is that the restrictions on the independence of states cannot be presumed. So what does that mean? That means that in international law, something is going to be inherently permitted unless it is expressly prohibited. There is no Leviathan that exists over the community of states. So when you're an individual living in a state, the state itself is the Leviathan over you as an individual. So the state can determine restrictions on your freedom, what you can and cannot do as an individual without your consent. You didn't have to consent to the law that says you have to wear a seatbelt while you're in the car. That law can still apply to you regardless. However, when we're looking at states at the international level, there's an expectation that states have consented to give up or limit their sovereignty due to their own choice. And so states may choose to do so because it's beneficial for them. They're getting another benefit as part of a larger agreement for limiting their own freedom of action, or a state sees it as worthwhile to limit the freedom of action of others in the same way. It's more beneficial to the state to limit the freedom of action of others than it would be to maintain, to keep that level of freedom of action for themselves. And so to give one example, if we look at the conventions on the prohibition on the use of biological and chemical weapons, states have decided that they're willing to give up the right to utilize those biological and chemical weapons in order to prevent other states from doing the same. And so states have consented by ratifying treaties to that end in order to modify their obligations in the international arena. So we expect that states are giving their consent to restrictions on their freedom of action. So I'm going to go through the different sources of international law with you to explain how states consent and how international laws are formed. So Article 38, Paragraph 1 of the ICJ statute is where you're going to find this definition of the sources of international law. And there are three different categories of sources of international law. The first one, which is the one we're going to talk about primarily today, is international conventions, expressly recognized. And so the Outer Space Treaty, for example, is an international convention. You can think of the terms convention and treaty as interchangeable for these purposes. As a note, the reason it says contesting states in this language from the ICJ statute is because these provisions are used to determine the rules that are going to apply for cases heard before the ICJ. And so if states are coming before the ICJ, they're coming before the ICJ in a contested case, and that's why they're contesting states. But these rules of international law apply regardless of whether they're being used specifically by the ICJ. Another note about the presentation is that any bold text, italicized or underlined text that you see is emphasis that I have added to draw your attention to those provisions, and that the treaty language you're going to see on these slides here is the language directly from these documents. The second source of international law, which is really important when we're talking about space law, is customary international law. And here we see it articulated as international custom as evidence of a general practice accepted as law. So there's actually two components, two prongs that are built into this language here, and you have to satisfy both of them in order to find that there is an existing rule of customary international law. So evidence of a general practice, we refer to that as state practice or consistent state practice when you hear lawyers talk about this. And what that means is that those states who are engaging in this activity are engaging in it in a way that their behavior is consistent, that you could find a rule, you could make a rule based on that consistent behavior of those states who are engaging in the activity. As a side note, you can have a state that's a persistent objector. So if they are the persistent outlier and they behave differently and object to a requirement that they not behave differently from very early on in the development of a customary international law rule, then they can be considered to be a persistent objector and can be exempted from that rule, not that the rule will not exist, but rather that the state will not be bound to it. If it's mixed practice and some states are engaging in one type of behavior and some states are engaging in another, then you will not have a rule of customary international law that will form at all because there is no consistent state practice. As another note, for those kinds of activities like space activities that require technological advancement, a high level of investment, and a commitment to that particular activity that not all states are going to engage in, the ICJ has stated that we can find customary rules based on consistent behavior among those states that are engaging in those activities. The ICJ commentary goes to specifically use of nuclear weapons, because that is also something that is engaged in by a very limited number of states, but we can take that and apply it to spacefaring states as well. The second prong, which is the important prong that we need to think about in terms of that Lotus principle, is accepted as law. We use a Latin term in international law, and you don't need to remember this, but if you see it, hopefully it'll raise the bells for you and you'll remember where it came from. Opinio juris is what we call this. That means that a state believes that they are bound to act the way that they're acting in their state practice. So the state practice is not occurring just because it is the most convenient, efficient, expedient, cheapest way to do something. But a state is behaving that way because they feel that they have to behave that way in order to conform with the standards of the international community. So how can you prove that a state accepts a rule as law? Well, one of the easiest ways to do so is if you have a statement by a head of state or a head of government or by the foreign minister of a country, somebody who is authorized to speak on behalf of the state, and they make a statement calling out another state's behavior, saying that another state is not conforming with a rule of international law, which their state conforms with, because it gives you evidence that that is in fact a rule of law. Likewise, if a state comes out and touts their own behavior and says that they're in conformity with international rules through one of those agents, like the executive or the foreign minister, then you see again there's evidence that the state believes that they're bound to that rule. There's a lot of discussion, a lot of argument over how you prove that opinio juris piece, how you prove that a state believes that they're bound. When it comes to the use of UN resolutions, you will see some scholars make the argument that if a UN resolution is agreed to and negotiated among states, even though it's not a treaty, it's not binding, it's not ratified, so it's not binding law in and of itself, but states have negotiated and agreed to it, and then behavior changes in conformity with that UN resolution, then you can argue that the behavior becomes the consistent state practice, and the resolution that changed the behavior is the evidence that states changed their behavior because they believed that they were bound to do so. And so there are, as I said, a lot of interesting discussions, many books written on the subject. How do you prove there's a rule of customary international law? How do you prove that a state believes they're bound to that rule as that second prong of customary international law? This becomes a really interesting point in a number of areas, and I'll talk about it in the second PowerPoint with regard to the question of delimitation between air and space. Accidentally skipped one there. Okay, there we go. The third primary source of international law, which means a rule of law in and of itself, is a general principle of law. It's written in the ICJ statute as recognized by civilized nations. That clause of the language has become less meaningful since the adoption of the UN Charter and the ICJ statute in terms of what does civilized nations mean. But general principles of law we typically think of as principles that are in place in a domestic legal system. So if you see that a rule of law is universal across all legal systems, whether we're looking at common law jurisdictions, civil law jurisdictions, different regions of the world, different forms of government, if that rule is consistent across jurisdictions internationally, then it's a general principle of law and you can recognize it into the international level. So the ICJ statute Article 38, paragraph 1B, customary international law, really addresses how states are treating each other on the international stage, their behavior on the international stage, whereas paragraph C deals with consistent rules that exist among those domestic legal systems. So paragraph C is far less useful to us in international space law than customary international law. We're going to be talking about customary international law far more frequently for space law than you would talk about general principles of law. Okay, finally, we have subsidiary sources of international law. What that means is that they don't form a binding rule of law in and of themselves, but that they can be used to determine what is a rule of law. And so for those pieces of assistance, we can look to judicial decisions. So decisions of the ICJ certainly are a very strong subsidiary source of international law. When the ICJ says, hey, there's a rule of customary international law that we recognize, that's a strong indicator for a subsidiary source of law that there is in fact a rule of law in place there. But you can actually also use domestic court rulings that address issues of international law. So if you look, there are Supreme Court cases that address international treaties quite frequently, and so you could use a Supreme Court case in the US that addresses an international treaty as a subsidiary source of international law, looking at how that international law is applied. We can also use the teachings of the most highly qualified publicists. What that means is the experts in that field. We can look at the publications and the statements of the most highly qualified experts in that field and use those to help us determine whether or not there is a rule of law. So I mentioned, when talking about customary international law, that there's a lot of scholarly interpretation of what constitutes opinio juris, and so therefore, we use that scholarly interpretation to support the existence of a rule of customary international law, or the lack of existence of a particular rule of customary international law. We're also going to use scholars to help with treaty interpretation under paragraph A, when we're looking at, okay, we've got a treaty, we see that states have consented, they've ratified that treaty. How do we interpret and apply that treaty? If there are issues of interpretation, we can use those scholars to help us. So getting into that treaty interpretation piece under the Vienna Convention on the Law of Treaties, Article 31 is the primary article that we use in talking about interpretation. We interpret a treaty in good faith in accordance with its ordinary meaning. And we give that meaning in context and in light of its object and purpose. And I highlighted or underlined object and purpose there so that we could talk a little bit more about what that means. So you'll see it unpacked as we go through the treaty language, but the context for the purpose of interpretation includes not only the text of the treaty itself, including its preamble and its annexes, but any agreement relating to the treaty made between the parties in connection with the conclusion of the treaty, and any instrument made by one or more parties in connection with the conclusion of the treaty that's accepted by other parties. So the preamble helps us to determine in particular the object and purpose of the treaty. The preamble language, that comes before, if you're looking at a treaty document, it comes before Article 1, Article 2. Right? It's not one of the articles, it's that language up front under the title and before the articles that sets the stage. Why do we have this treaty that we've agreed to? What's its purpose? And so we use that to help us interpret, even though that language in the preamble is not operative in and of itself. The preamble language does not in and of itself create specific rights or obligations. In addition to the context, we'll take into account any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, and any subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation, as well as any relevant rules of international law applicable in the relations between parties. So I want to make a couple of comments here about soft law instruments that can include UN resolutions, which I mentioned earlier, but can include norms of behavior or standards documents that are not in and of themselves binding law, but that can contribute under the right circumstances to the development of binding international law. So if you have a resolution, for example, some scholars would argue that that could qualify as a subsequent agreement. It's not a subsequent treaty, but it's a subsequent agreement between the parties that could be applied to interpretation of a treaty. So there are a number of resolutions, and we'll talk a little bit about some of them in the next PowerPoint, that could be argued to help interpret some provisions of the Outer Space Treaty, and in particular Article 9 of the Outer Space Treaty. In terms of subsequent practice, those sorts of soft law documents that are not inherently binding can help states to bring their practice into a set of consistent behavioral patterns. And so if states shift to behaving consistently in line with those documents, then you can argue that you have subsequent practice in the application of, say, the Outer Space Treaty, and therefore that establishes an agreement that, okay, the behavior in this practice is in alignment with the treaty because multiple members of the treaty have moved to conformity this way. In fact, we're not seeing deviation from that standard. Likewise, if you see behavior under the treaty that you might argue could be constituted as a violation of that treaty, you will look at the practice of states who are party to that treaty and see how many of them are engaging in that behavior, and if states are engaging in that behavior, whether other parties to the treaty, other states who are members of that treaty, have objected to that behavior to say that it's a violation of the treaty. If there are multiple states who are behaving in that way, and there are not objections by the other states to say that that behavior is violating the treaty, then you can, in the principles of treaty interpretation, say that subsequent practice under that treaty has established that that particular behavior does not constitute a violation of the treaty. We have to interpret the language of the treaty in such a way that that behavior is considered acceptable under the treaty. As a note, a special meaning can be given to a term if it's established that the parties so intended. So I always say if there's a definition section, you could say in that treaty, for the purposes of this treaty, a table is defined as a chair, and a chair is defined as a table. And if that were to be included in the treaty, then you have to treat those terms the way that the drafters have intended and spelled out in that treaty. So Article 32 of the Vienna Convention on the Law of Treaties gives us supplementary means of interpretation, additional tools that we can use when we can't get to a good result based on the Article 31 tools alone. So the only time you can use your Article 32 supplementary means is if the meaning of the language in question is ambiguous or obscure even after you've used your Article 31 tools, or if your Article 31 tools lead you to an absurd result, a result which is manifestly absurd or unreasonable, then at that point you can step on and use your supplementary means of interpretation under Article 32. So at that point we can use the preparatory work of the treaty and the circumstances of its conclusion to help us with interpretation. So there's a French term, and if you Google, you'll see that documents get referred to this way, and I apologize because my French pronunciation is atrocious, but travaux préparatoire, which translates to preparatory work, but it typically does get referred to in the French. Even in English documents, you'll see the French term used. It's really the negotiating history of the treaty. So for UN Copious, which is the body from which the Outer Space Treaty and its progeny have come, you can look up that negotiating history, the travaux préparatoire, and see what states had to say about the language. So how can that help us? Well, in that course of negotiation, there'll be multiple drafts, multiple versions of the language that get proposed, and when you see states objecting to that language on certain grounds and asking for it to be changed, and then it's changed in the final draft, then you can assume that the meaning that was objected to under the original version of the language is not the meaning that was intended in the final version of the language that was agreed to in the ratified treaty document, for example. Okay, and then Article 33 is relevant specifically to our space law treaties because when a treaty has been authenticated in 2 or more languages, the text is equally authoritative in all of them unless the treaty specifies that one version takes precedence over the others. So the Outer Space Treaty and its progeny are authenticated in all 6 UN languages, and so therefore all 6 versions are equally authentic, and thus if you have a different word across each language that's used, you need to take into account a meaning that is most harmonious among the language used in all 6 versions in those languages. Okay, and then I'll give you a little bit of background here on state responsibility. So there's a document called the Articles on the Responsibility of States for Internationally Wrongful Acts. We refer to that as the Articles on State Responsibility. That's how you'll hear folks in the community talk about it. It is not a treaty document. It is not binding. It does articulate a number of pre-existing rules of customary international law. And the International Law Commission, which is probably the most highly qualified publicist source that you can use under your subsidiary means of interpretation, is the body that generated the Articles on State Responsibility. So it helps us to understand not only when states are responsible for their actions, but what sorts of outcomes you can get in order to resolve an issue of a wrongful act on the part of the state. And so what is a wrongful act, and how do you deal with that wrongful act in international law? So a violation of a rule of international law is typically what we're going to think of as a wrongful act, whether that's a treaty rule, whether that's a rule of customary international law, etc. So some important aspects of this document are the explanations of what are wrongful acts in international law, but also circumstances precluding wrongfulness. So necessity, for one example, is a circumstance precluding wrongfulness, and it's articulated in Article 25 of the Articles on State Responsibility. And so if a state acts out of necessity and meets all of the prongs of necessity under the Articles on State Responsibility, which is considered a codification, or rather an articulation, it's not a codification because it is not binding in and of itself. The VCLT is a codification of customary international law dealing with treaty interpretation, but the Articles on State Responsibility are an articulation of those rules. The VCLT codifies because it is legally binding for those states that are party to it. The Articles on State Responsibility are not legally binding in and of themselves. A note on the VCLT while we're talking about this, so the United States is not party to the VCLT, but you will see statements from the State Department, the US State Department, that many of the rules of the VCLT are considered to be customary international law, and thus the United States considers themselves bound to those rules. So that's meeting your opinio juris prong, including the treaty interpretation provisions. There are also numerous ICJ cases that cite articles of the VCLT, including the treaty interpretation articles, as representing pre-existing rules of customary international law. So that's why we use the VCLT, even though the United States is not directly party to it. So when we're talking about circumstances precluding wrongfulness, like necessity, so if a state is dealing with a grave and imminent danger and they have to act in order to mitigate or prevent that grave and imminent danger, they can take an action that would otherwise be a wrongful act, would otherwise be a violation of a rule of international law, providing that they don't have another viable alternative course of action that they could take, and that course of action does not unduly infringe on the rights of other states when they carry out that action under necessity. So one example that I give when I'm talking about necessity has to do with deflecting an asteroid. If we were to have a near-Earth object coming towards Earth and we needed to remove it from Earth's path, if we wanted to explode a nuclear weapon in space, that would be a violation of the Limited Test Ban Treaty. But if that's the only way we have to mitigate destruction caused by an asteroid, you could explode a nuclear device. I won't even call it a nuclear weapon because it's being used as a tool, but explode a nuclear device to move the path of that asteroid and make a very strong argument that that is not a wrongful act, even though it would otherwise be a treaty violation, because it was necessary to prevent that damage from the near-Earth object. Necessity cannot be used for acts of force, uses of force against another state. If you're talking about a use of force against another state, then self-defense would be the correct circumstance precluding wrongfulness that you would want to use. Self-defense is articulated in the Articles on State Responsibility. It's also articulated in Article 51 of the UN Charter. Article 51 of the UN Charter is binding, whereas the articles are themselves non-binding but represent the existing customary international law rule of self-defense. There are other circumstances precluding wrongfulness that include force majeure and also include countermeasures. Countermeasures are actions that would be wrongful but are short of a use of force, and states can employ countermeasures in order to induce compliant behavior with international law from other states when other states are violating international law, as long as those countermeasures are temporary and reversible, and as long as there has been notification made that the countermeasure is being employed specifically for the purposes of inducing the violating state's compliance with the pre-existing rule of international law. So very briefly on the law of war, as I mentioned, also applicable in space. So we have two components to the law of war: jus ad bellum, which is prior to an armed conflict, that determines whether or not an initial use of force is going to be considered lawful. So as I mentioned, Article 51 of the UN Charter, self-defense, a use of force that is employed in self-defense against an armed attack of another state will be considered a lawful use of force under jus ad bellum. Jus in bello is once you're already in an armed conflict, so that's the law that governs the conduct of hostilities between states. So here we have that spectrum of conflict for the jus ad bellum perspective, so before we're in an ongoing armed conflict. So I've mentioned these terms, use of force and armed attack, and again, this is a whole class in and of itself, but the United States policy is that use of force and armed attack fall at the same point on this spectrum of conflict. So if another state has used force against the United States considers that to be an armed attack, and therefore the US can use force, legally speaking, in response. You cannot use force in response, legally speaking, for something that is less than a use of force or an armed attack, even if it is still a violation of international law. And like I said, there are other tools that you can use that are not use of force, such as countermeasures, that would be lawful in the case of a treaty violation that is not something that rises to a use of force or armed attack. For jus in bello, there are 5 major principles that you want to look at in terms of whether a particular action is going to be a lawful action in the conduct of hostilities. Some of these are a bit more complex to apply and require a little bit more thinking and discussion to apply in an outer space context. You're probably familiar with these terms in general, but military necessity, distinction, proportionality, humanity, and honor. There are 2 efforts ongoing right now in order to help apply the laws of armed conflict to the outer space environment. So one is the Woomera manual that's being developed by the University of Adelaide in partnership with the University of Exeter. And then there's the McGill manual being developed in partnership with McGill University in Canada. There are a number of international partners involved in both projects addressing some of these questions. And so those will be interesting sources as subsidiary sources as the writings of the most highly qualified publicists to help us interpret how we employ LOAC principles in outer space. So that concludes the first PowerPoint presentation. So we'll move on, and in the next one have a discussion of international space law. Thank you.